Okay, Mr. Mayor, we are now live. Please go ahead.
Thank you, Madam Clerk. I'll call the meeting to order. Our land acknowledgement statement. We acknowledge with respect the history, spirituality, culture of the Anishinaabe, the people of the three tribes known as the Ojibwe, Odawa, and Potawatomi nations, who have inhabited this land from time immemorial. And further give thanks to the Chippewa, Saugeen, and Chippewa Nawash, now known as the Saugeen Ojibwe Nation, as the traditional keepers of this land. We also recognize the Métis, the Inuit, whose ancestors shared this land and these waters. May we all, as treaty people, live with respect on this land, and live in peace and friendship with all this diverse people. Moving on to the agenda, we're down to appointment of Secretary Treasurer. The recommendation is that the Committee of Adjustment appoint Chloe Rayburn as Secretary Treasurer of the Committee, and that said appointment take effect immediately. Someone move to the floor, please. Moved by Councilor Pringle, seconded by Deputy Mayor Carlton. Is there any discussion on the motion before us? See none. A show of hands, all in favor? Thank you. Okay, Chloe, you go to work. Approval of the agenda. The recommendation is that the agenda be approved as presented. Someone to move to the floor, please. Moved by Councilor Colburn, seconded by Councilor Thompson. Is there any discussion on the motion before us? See none. A show of hands, please. All in favor? The motion is carried. Declaration of pecuniary interest be declared anytime you see fit during the meeting. Minutes of the previous meetings. The recommendation is that the minutes of the Committee of Adjustment held on July 13th, 2021 be adopted. Someone to move to put on the floor, please. Moved by Councilor Bartlett, seconded by Councilor Pringle. Is there any discussion on the motion before us? See none. Show of hands, all in favor? The motion is carried. We're now down to new business. We have two applications before us here today. This meeting of adjustments to consider the application for minor variance for Dan Burrows under Section 45 of the Planning Act regarding property legally described as Concession 2, NCD Lot 36, Registered Plan 16R393, Part 2. Would the Secretary Treasurer please give your report?
Thank you, Mr. Chair. There has been no request for deferral or withdrawal of the application. Notice of this minor variance hearing in accordance with Ontario Regulation 296, made under the Planning Act, was given on July 15th, 2021 by ordinary mail to all property owners within 60 meters of the property which is subject to the application, and to all the required agencies. Notice was also posted on the subject lands and the township's website. If you wish to be notified of the decision of the Committee of Adjustment, you must make a written request to the Secretary Treasurer of the Committee. Only a person or public body that requests a notice of decision of the committee in respect to this proposed minor variance may submit an appeal. Could the planner please give us the updated planning report regarding this file?
Jen, go ahead.
Thank you, and good evening to the committee. So the purpose of this application is to reduce a side yard setback and an exterior side yard setback on a 1 acre property to allow a single detached dwelling to be built. The lot is it's about 36. It has 36 meters of frontage, and the setbacks on this property amount to about 25 meters. So that would leave approximately 11 meters for the property owner to be able to build a house. So they like to reduce the setback just so that they can get the house that they the design that they're interested in building. When we look at granting a minor variance, we consider whether or not the application meets the 4 tests of a minor variance. So the first one is that the variance must be minor. It is a minor variance. The proposed dwelling, it's a permitted use in a residential zone. The reduction in the setback for the interior side yard isn't anticipated to have an impact. Our zoning bylaw allows a dwelling to be located on a property and to reduce our side yard setback to 2 meters where there's an attached garage. So for that interior side yard setback to be reduced, there are other provisions in the bylaw that allow that to occur. So it's not a it's considered a minor request. On the exterior side yard, the request is to reduce the exterior side yard from 15 meters to 6. On that exterior side yard, there's an unopened road allowance. So I consulted with the operations department, and where that unopened road allowance would terminate would be a provincial highway. So the ministry is not keen on opening up additional roads through to a provincial highway. The other thing is that when we looked at the adjacent property, we saw that the property in behind this one, where you would see the unopened road allowance come through, actually has part of their farm buildings and their operation on that unopened road allowance. So I think technically, unless the municipality went in and demolished some of those structures, it wouldn't be an easy case of opening that road allowance. So given the fact that the operations department doesn't have any intention of opening up that unopened road allowance, and that the ministry would be really reluctant to permit an additional road entering onto the highway, we would consider the request for the variance to the exterior side yard to be minor. It must be an appropriate or desirable use of the land, building, or structure. The lands are zoned rural. They're intended for residential uses, and it's an existing lot of record. They're just applying to reduce this side yard, so we would consider it to be appropriate. It must maintain the general intent and purpose of the official plan. So in the county official plan, the property is designated rural, residential uses are permitted. And we also had MDS was calculated for livestock facilities within 750 meters. And the proposed location of the dwelling is outside of the required setback arc from the nearest livestock facility. So it does meet the intent of the county official plan. So it must maintain the general intent and purpose of the zoning bylaw. The reduction, as I mentioned, wouldn't have any impact, would have minimal impact on that unopened road allowance, as there is no plan for that road allowance to be opened. So we can determine that the application meets the general intent and purpose of the zoning bylaw. The comments that we received back from the agencies, Grey County Planning and Development Department, the Conservation Authority, and the Risk Management Office, as you see in the report, they didn't have any concerns with the application. And this application was circulated to all property owners within 60 meters, and we did not receive any comments back from any of them. So as noted in the recommendation, it's recommended that this application be approved. And I'd be happy to answer any questions that the committee may have.
Thank you, Madam Planner. I guess I'm going to ask the secretary. We never had anyone registered to speak to this from the public.
No registrants.
Thank you.
Thank
you. So I'll move on my script then, please. I now call none from the public. Are there any points raised by the applicant or committee public that anyone wishes to speak to? Does the committee have any concerns or questions? Seeing none? I'll now call for a motion on this decision. Okay, I think since there's no question on this, I'll ask for adjournment of this public meeting. Moved by Carol, seconded by Grant. All in favor, show of hands, please. Thank you. So we'll
So we'll move on to our
next.
next.
No,
I'll go back to my,
what I
what I
wanted
wanted
to.
to.
I have a
I
recommendation
recommend
here.
Mr. Mayor, if I may interrupt, there's a recommendation associated with that application, specifically that it be approved.
Yeah, I see.
Yeah, I see.
Thank you,
Madam Clerk.
Recommendation is
application
A0521
A0521
for
for
dam
dam
burrows
burrows
be
be
approved.
approved.
Someone to move
Someone
to
to
put on
move
the
to put
floor,
on the floor,
please.
please.
Moved by
Moved by
Councilor
Councilor
Colburn,
Colburn, second by Councilor
Thompson.
Thompson.
Is there
Is there any discussion on what's before us?
Seeing none?
Seeing none?
A show of hands,
Show of hands, all in
favor?
favor?
The motion
The
is
motion is
carried.
carried.
Okay, and
Okay, and now we're moving on to our second
meeting here
meeting
tonight.
here tonight.
This
This
meeting,
meeting,
this is a
this
meeting
is
of
a
the
meeting
Committee
of
of
the Committee of
Adjustment to
Adjustment
consider the consent
for
for
John
and
and Pat
Johnson
under Section 53 of the Planning Act regarding property legally described as concession to
the
a
CD
CD
west
west
part
part
of
of
Lot 1.
Lot 1.
Madam
Madam Treasurer, please
give your
give your
report.
report.
Thank you, Mr. Chair. There has been no request for deferral or withdrawal of the application. Notice of this consent in accordance with Ontario Regulation 197/96 made under the Planning Act was given on July 15th, 2021 by ordinary mail to all property owners within 60 meters of the subject property which is subject to the application and to all the required agencies. Notice was also posted on the subject lands and the township's website. If you wish to be notified of the decision of the Committee of Adjustment, you must make a written request to the Secretary Treasurer of the Committee. Only a person or public body that requests a notice of decision of the Committee in respect to this proposed consent may submit an appeal. Could the planner please give us an updated planning report regarding this file?
Thank you. So this application essentially is to create a 4.4 acre lot for residential purposes, leaving an approximately 88 acre lot with a dwelling and a barn. When we look at the policies that that we need to consider for this application, we see that they're generally supportive of the application. Under the county official plan, the lot, this property is designated within the rural designation. So lot creation policies there speak to density. Lot creation can occur subject to a specified density. So the original township lot was 80 hectares in size, and the county policy permits a maximum of 6 lots to be created from that original 80 acres. So in this situation, the lot that's being proposed would be the 6th and final lot available. Schedule C shows that there are core areas and linkages on the lands. However, lot creation is proposed outside of that area, so there's no contravention of the policy there. The Appendix A of the county plan identifies karst on the property. So the applicant did provide documentation in support of the applications that shows there are no or minimal features on the subject lands, so there's no concerns noted related to karst. Appendix E of the county official plan identifies a potentially significant layer of bedrock. The county has reviewed this and they're satisfied with the application, and they're not requiring that, that this feature be addressed. So the Conservation Authority, as you know, they review applications under a memorandum of understanding for the township. They effectively provide their expertise when it comes to natural heritage features and natural hazard features. So they do note that there are significant woodlands on the entire property. However, and there are, there may be undocumented natural heritage features within the larger vicinity of the property, potentially associated with significant wildlife and or habitat of endangered species and threatened species. So, but they are not present on the severed parcel. They provided comments to us that note that a review of the Natural Heritage Information Center records indicate records of bobolink and eastern meadowlark to the southwest of the property along the Derby-Keppel town line. The barn structure may also support support barn swallow, and they're recommending that the property owner contact the Ministry of Environment, Conservation and Parks should these species be encountered prior to development of the severed parcel. They're not requiring any special development considerations as part of this application. The minimum distance separation calculation was calculated, and the proposed building location meets the MDS setback requirements of both barns within a 750-meter radius. So another section of policy that we need to look at, as the property fronts onto a provincial highway, the county official plan as well as the PPS both speak to protecting the interests of that highway. So the property owner was previously engaged the MTO to seek permissions to obtain a shared access off of the highway in order to be able to create this lot. So when we look at the county policy and the MTO policies, they are supporting a mutual access. So in the report, we did include the section of the county official plan that supports mutual accesses where possible, as well as in the preliminary comments from the MTO, they advised the property owner that they would support a mutual access through this application. At the time of writing the report, the MTO hadn't returned formal comments to our office. I did receive comments later on this afternoon, and the MTO reiterates the comments they provided previously. They are just asking for the property owner to provide an easement, register the easement on both the severed and retained parcel, as well as to register effectively a 1-foot reserve along any portion of the property that could be accessed by the highway. So when the property, if the committee supports the severance application, what would happen is as part of the survey process, the property owner would move forward, have a 1-foot reserve surveyed, in addition to surveying where that mutual access is going to go, and then registering a right-of-way or an easement agreement over in favor of and over both properties, so that new lot will always have access through the existing lot to get to their home. The other thing that staff, what we recommend, is that easement address maintenance and snow clearing, so that in future years, when there are new property owners there, they are aware when they purchase that property what their rights and responsibilities are. One of the things that we have noticed in the past is that when there are mutual accesses granted, if it's not made clear who's responsible for snow clearing, it creates a lot of conflict between the property owners. So we would ask that as part of the process, that the applicant's lawyer include that in the wording of the easement. That's a requirement. The access easements are a requirement of the MTO. They provide specific details on what needs to be provided to their office for that access permission to be granted. So at this time, my recommendation is still to defer the decision on this application because while a mutual access is supported by the MTO and the county in their policy, our zoning bylaw requires that each lot have its own access. So I did speak to the applicant. A zoning amendment application is forthcoming, but what I want to do before the committee approves this application is just to further review the proposed location of the driveway and the access to make sure that when the committee considers approving the severance application, that we only have to do this once and that everything is covered in the conditions of severance. So so generally, in summary, the application except for the access at this point, would meet the policies. And the recommendation at this point is just to defer the application, or the decision on the application, until we can get the zoning sorted, as well as the location of the driveway. The comments that we received for this application, as you can see, is the Conservation Authority. They are satisfied with the application. The Grace County Planning and Development Department are satisfied with the application. They are not going to require additional information on the bedrock feature. Bell Canada, Hydro One, and the Risk Management Office all noted no concerns or comments on the applications. We circulated the application to all the property owners within 60 meters, and we didn't receive any comments back from any of the neighbors. And I would be happy to answer any questions the committee may have. And I see that the applicant, Mr. John Johnston, is in the meeting this evening. Thank you.
Thank you, Jen.
Thank you, Jen.
One member of the public wishes to provide comments in support of or opposition of the application. I'll now call on Mr. Johnson to make comments on this application. Please state your first name, last name for record, please. Go ahead. Go ahead, John.
Good evening. It's John Johnston. I certainly appreciate the opportunity to address the chair and members of this committee. And I do have a couple comments, if I may. As I think as the committee and the mayor knows, MTO certainly are difficult to deal with when it comes to entrances on Highway 6. But through certainly the mayor's help and Bill Walker's help, I went through an appeal process, and they approved a mutual entrance. The entrance would be the existing entrance that I have now. We're not locating it anywhere else. They said it has to be the one you have. And in that appeal process, I provided a entrance and maintenance easement agreement to them. And they were certainly happy with it. And I think based on that agreement and the other things I provided, they approved a mutual entrance. So the entrance that exists now will be the entrance that I would need to use. It would, there would be an easement from that entrance to the property. And there's no construction, no work at all on the highway right of way. All the work would be within this easement that I would provide. So I guess my question would be to the committee, to the chair and committee, would it be possible for the committee to approve the application tonight, subject to staff and council or committee reviewing and approving the agreement that I sent to the highways, which they approved? I mean, I can go through the zoning amendment process. It's an application and it's a justification report. I can do that, and it's another couple $1,000s to pay. And I'm wondering if I go through that process, at the end, the same result will happen, that, you know, I'll get an approval with the agreement. So is that a possibility or not?
John, I'm going to refer that back to the planner. Jen, you want to comment on that, please?
We can't make a condition in the severance based on a document that doesn't involve the township. So what it is, it's for council to review the document that the township, or that the MTO, the agreement that the MTO would have with Mr. Johnson. We can't make that a condition of consent. So my recommendation to defer the decision, you know, it's not for months. It's until we get the zoning application and ensure that everything that needs to be provided to the MTO is on that site plan. They have commented that they want to review the zoning amendment application, which they were required to circulate them on. But the intent of this was just to save Mr. Johnson, you know, some time in the long run. If council if the committee goes through and approves a decision on the application, and there's something else that needs another condition that needs to be added, or if there's something that needs to be changed, then we need to go through a process of amending the conditions again. So just to do it all in one motion. So generally when you have a severance application approved, unless you've got a survey, ready to go, it'll take a couple of months to get everything in order for us to be able to stamp the deeds for that severance. It's not something that is, if it's approved tonight by the committee, the appeal period is 20 days. It's not going to be stamped on the 21st day, because there are requirements for easements to be registered, and that's a process that takes a number of weeks as well. So deferring the decision on the application right now isn't going to effectively hold it up any longer than having the zoning amendment application considered.
Madam Planner, this request does not have to come back to the Committee of Adjustments again.
So I would bring forward an addendum report identifying that the application, the zoning amendment, had been received and there's no issues with this application as presented, and then make a recommendation for the committee to approve the severance and bring forward a decision.
Mr. Johnson,
and that could be done, as soon as next month.
Okay, Mr. Johnson, may I ask, were you trying to start your building of your new home this year?
I've been trying to get this process through for 9 years, so I'd like to do this as soon as I can, but I'll have to follow the process, and I recognize that. I just wonder if and when this is approved, it will be approved with conditions. The conditions will be, I need to have a legitimate agreement that the township wants and agrees to, and whatever else there is. So I guess what I'm saying is, can that not happen now? And then severance is subject to these conditions. I bring forward all the things you need and have the deed stamped at that point, provided you're happy with it. I guess that's what I'm just trying to cut out one more process so I can get on with it. But I certainly, will listen to the planner and committee for sure.
Thank you,
Mr. Johnson. Any comment, Tim, for the committee?
Yeah, so there are conditions listed in the staff report, and so they generally, they're the standard conditions. So there's nothing there requiring the owner to enter into an agreement with us that would prolong the process. What is there? So I'll just really briefly, every severance has to have a reference plan registered. So unless an exemption is received from the registry office, everyone who comes forward with a severance for new lot has to provide a reference plan. So that involves time for a surveyor to go through it and draft that up and send it along. So there's also a consent certification fee. So there is a fee charged by the township to review all of these documents once the severance is approved, and to stamp the deed and to make sure everything being approved is what was approved by the committee. There's also a cash in lieu of parkland requirement. So that's 5%, that's standard. And that is paid up by the property owner before we stamp the deeds. And we ask for an estimate from someone who's qualified to do that. So one of the local realtors or an appraiser can give us an estimate on the value of that lot for us to calculate what the cash in lieu of parkland is. One of the the other one is that a zoning amendment be in force and effect. That's a standard condition when we see that an application doesn't, as of right, meet the zoning bylaw. Number 5, that's in your report there for the conditions that I would recommend that you consider is that the applicant's solicitor provide an undertaking to register that easement for ingress and egress of persons and vehicle in favor of the severed lot. So that's not just something that the township is asking for, the MTO is asking for that as well. So as part of that, the MTO, as I mentioned, they're requiring that that be surveyed and that that survey be provided to them as part of the application that Mr. Johnson will make to them for his access. So we would have that as well, and that that it identify that who's responsible for snow clearing if there's any sort of conditions that way, so that in the future that there's it avoids an opportunity for conflict between 2 new property owners. So there's no with the submission of the zoning application. I would be able to sit with Mr. Johnson and make sure that the proposed location, the entrance, and all of the information that's being provided is there's no issue with it, and that he's meeting the MTO requirements, and then I would be able to bring back a report to the committee as well as a decision. So we do have a draft decision available. We do have it ready for tonight. If the committee wants to do that, then it is available. I'm just because of the way the MTO comments were worded, I would like the opportunity to sit down with Mr. Johnson just so that we can make sure that it's being done right, and that he'll be able just to move forward and have his and meet the conditions of his severance with minimal difficulty.
Go ahead, Mr. Johnson.
Thank you, Mr. Chair. I understand all of that. I'm not sure what the zoning amendment would do any more than what I could do sitting down with Jen and looking at the agreement I have, that the legal agreement I have, maintenance and access. Certainly, I know what the highways want, and I don't have the a reference plan. I don't have the survey set up. I can't set anything up till I know I can get a severance. So I can't do that. But if I hear that I can get a severance, I'll start that process right away. And I certainly sit with Jan. But what would a zoning amendment, if I do the justification report, I fill out all the applications, how far ahead am I by doing that? Like, what difference does it make if I bring all the stuff now? I wonder about that.
Jan, are you able to answer
that? I'm sorry, I don't understand. I don't understand your question. If you do not have a zoning amendment, then and have that approved by council prior to this application lapsing, then we cannot stamp your deed. So because you don't have direct access onto an open and maintained road, you're going through a mutual access, it doesn't meet the provisions of the zoning bylaw. So you need the zoning amendment. So I'll go through this process and pay another $2,000 so that I can get that amendment that says you now have access through an easement agreement, through an easement to the highway. Is everybody going to be happy with that, or do I go through the process and someone's going to say, I don't think you should have an entrance there? Not the highways, they've already approved that.
So go ahead, Jan.
Sorry, Mr. Chair. So from a planning perspective, when I look at the policies that are here, I can't speak for the decision of the committee, but when I look at what's the policy review, you're meeting all the policy requirements. The one that you don't meet is the zoning. So your application would go to the council of the Township of Georgian Bluffs, and because the policies in, for example, in the official plan support a mutual access, as well as the policies for the MTO require a mutual access for your situation, then we, as a planner, I would see a justification in recommending to the council that that it be supported. So that being said, I can't speak for the committee on their decision, and I can't speak for council on theirs. But from a policy review, the zoning would be necessary. The amendment would be necessary to amend the bylaw to permit these specific properties to have a shared entrance, because in this situation, it can be supported by two of the agencies that have a say in the entrance.
Thank you, Jen.
Thank you, Jen.
Mr.
Mr.
Johnson,
Johnson,
I do not feel that this committee can say yes or no that we'd approve this application, but I see no justification why we wouldn't approve it. I can say that. According to what the planner is saying, we have all these things in place, zoning, everything else. There's no justification why we, as a committee or a council, would refuse this severance. I can say that. And if you don't mind, Mr. Johnson, I'd like to just open the floor up to the committee, see if they have any comments first. Some open the floor up. Did Carol, any comment? Councilor Bartlett?
Thank you, Mr. Mayor. Mr. Johnson, when I was reading my agenda, I looked at all your documentation that you've been given to the planner, and I thought, man, this is good. This should be an easy decision. But MTO raised their head. I just want to understand this. So MTO's asked for a foot across the entire property.
What about the lots that have already been taken off? So they're taking a foot across the entire property. And for what purpose is this? And how many driveway entrance permits do you have to pay for here?
Jen, I believe you outlined that quite plain and clear what Mr. Johnson had to do. I assume the 1 foot reserve is have control of the lot, no other entrance comes out other than where the joint entrance is going to be. I assume that's what the 1 foot reserve is for. It makes sense. The joint driveway doesn't meet our zoning. That's why we need the zoning change. And it sounds like it should be fairly straightforward to get that. And I can understand why you have a concern with Mr. Johnson is living in the house now, but he maybe will sell in the future, and maybe he'll build a new house and won't live there. So you have two different people coming out that driveway, so you need some control on there so that to keep the peace between the two neighbors, which the car would never be. But I can understand exactly what you're trying to do. It's just that we have a protocol we have to follow, Mr. Johnson, and I think the planners outlined it very well. And I will not go against what she's saying. I think she makes perfect sense what she's asked me to do. Any other questions of the committee? Mr. Johnson, I'll let you have the last word.
Thank you, Mr. Chair, and members of the committee, and Jan, for all the effort that you've gone through. And I appreciate that. I'm just, I guess I was trying to speed up a process that can't be sped up. And I certainly understand zoning amendments and so on. So I will carry on with that process. I just want to make sure that I'm doing it right. And so, Jan, I hope I can sit with you in the near future, and you can coach me so that when I do put in the report and the application, that I'm not missing something and I have to go through some more detail. So thank you very much for allowing me to speak. I appreciate that. Thank you.
Thank you, Mr. Johnson. What we've seen with your paperwork coming through to this committee, it would be the same to the council. It's 100%. You've done an excellent job, and I'm quite sure sitting down with the planning department, Jen, and Tom, it'll be an easy process, and you'll both come out with a great understanding. Okay? So if the committee has no other questions on this application before us, I gotta
I gotta
apologize.
apologize. It's just a little confusing because
It's a little
it's
bit
a little bit
different.
that's why it seemed to be
a little
a little out
out
of
of
this.
this. I'm gonna
I'm
call
gonna call for
adjournment
adjournment of this public meeting.
Moved by
Moved by
Carol,
Carol, second by
Grant.
Grant.
Show of
Show of hands, all in favor?
Is
Is
carried.
carried.
Now I'm
Now I'm
gonna
gonna
go
go to my
other
script.
I have a
I have a recommendation here that
the
says the city.
wow, is that
The
reading? The
The
recommendation is that the decision on application
B0621 for John and Pat Johnson be deferred until positive comments have been received from the NTO.
Does that
Does that motion cover what you're asking for, Madam Planner?
Could I suggest that the pending comments of positive comments of the MTO be removed from the motion?
Yes.
Yes.
You can
make the motion whatever way you see fit,
Planner.
Planner, how would you like the motion to read?
Pending further information?
Okay.
Okay.
So the
The secretary has caught that change.
Yes.
Okay.
Okay.
Thank you, Chloe.
Thank you, Chloe.
So the
So the motion was
read
and
amendment was made
was made to the motion. I believe we can just vote on the main motion now.
I don't
I
hear
don't hear Madam Treasurer
jumping
in so that I'm safe.
Okay.
Okay.
Yes, if you'd like, I can read that recommendation. Just to clarify, the recommendation is that the decision on application B0621 for John and Pat Johnston be deferred pending further information.
Thank you, Madam
Secretary.
The committee has
seen
heard the
recommendation.
recommendation.
Show of hands, all in favor?
Mr. Mayor, if I may, you need a mover and a seconder first.
Sorry, I
just want to see you still there, Madam.
I need
somebody to move by Deputy Mayor Carlton, second by Councillor Bartlett.
Yes, there's no
There's
other
no other discussion on the motion.
Show of hands,
all in favor of the motion before us.
The motion
is carried.
Thank you.
Thank you, Mr. Johnson.
So,
So,
moving off
our
our
agenda, we know as our unfinished business.
Our next
Our
meeting
next meeting is October 19th at 5 p.m.
So I guess
we need a motion to adjourn.
Moved by
Councillor Pringle, second by Councillor